You filed your workers' comp claim months ago. You're still treating. Or maybe you're done treating and you're waiting to hear something. Every few weeks, you call the adjuster and the answer is the same. They're still evaluating. You search online for how long this is supposed to take, and you can't find a straight answer. You start wondering if you missed something, if you signed something you shouldn't have, if there's a number you were supposed to call. This is the point where most injured workers in Illinois either give up and accept whatever comes next, or finally call an attorney. The question, when will workers' comp offer me a settlement in Illinois, has a real answer. It's not whenever they feel like it. There is a process that governs when settlement conversations happen, what triggers them, and what the insurance company is doing during the time you've been waiting. Understanding that process doesn't just reduce the frustration of waiting. It tells you whether you're being treated correctly and whether there's anything you should be doing right now to protect your position. I'm going to give you the honest version of this conversation, not a sales pitch, just what the process actually looks like and what to make of where you are in it. Why insurance companies do not rush to settle. The first thing to understand about workers' comp settlement timing is that delay benefits the insurance, not you. Every week that goes by without a settlement is a week the insurance company keeps its money. Delay can benefit the insurer financially by postponing payout. They're also watching your case develop, tracking your treatment records, monitoring your activity, waiting to see whether you return to work voluntarily, whether your treating physician changes their assessment, whether you get frustrated enough to accept a low number just to be done. The insurance company is not on a deadline to offer you a settlement. They'll make an offer when they're ready. And they tend to get ready when one of a few specific triggers moves the case to a point where a number makes sense from their perspective. Until then, waiting is a strategy, not an oversight. This is frustrating to hear if you've been sitting with an open claim for 4 months. But knowing that the delay is intentional changes what you do about it. What actually triggers a settlement offer? There are 3 main triggers that move an Illinois workers' comp claim towards a settlement offer. The first and most common is MMI, maximum medical improvement. This is the point at which your treating physician or the insurance company's IME doctor, or both, determine that you've recovered as much as you're going to from the work injury. Once MMI is declared, your temporary total disability benefits are no longer appropriate because you're no longer temporarily totally disabled from the injury. The case transitions from a benefit-paying phase to a valuation phase. The insurance company will often begin settlement discussions at or shortly after MMI because that's the moment they can calculate what the permanent partial disability component is worth. The second trigger is a change in medical status that affects benefits. If your treating physician moves you from full restriction to modified duty restriction, or from modified duty to full clearance, the insurance company views each of those transitions as a pressure point. Modified duty clearance can affect your TTD payments. Full clearance often leads to a settlement push. The third trigger is the arbitration timeline. If a case has been filed before the Illinois Workers' Compensation Commission and a hearing date is approaching, the insurance company has a hard deadline. Cases often settle in the weeks before a scheduled arbitration because both sides want to avoid the costs and uncertainty of the hearing. The IWCC's arbitration docket creates urgency that the natural passage of time does not. Workers who have attorneys filing petitions and pushing the case towards the hearing schedule tend to see settlement offers materialize faster than workers who are waiting on the adjuster to call. The difference between a voluntary settlement and one forced by the timeline. The distinction matters. A voluntary settlement is one the insurance company initiates because they've assessed the case and decided the number makes sense for them. They pick the timing. They control the framing of the offer. Workers without representation often receive voluntary settlement offers at or shortly after MMI, when the insurance company has finished building the medical record they want and has a basis for the number they're presenting. A settlement forced by the arbitration timeline is different. When a petition has been filed before the IWCC and the case is moving towards a hearing, the insurance company now faces costs, defense counsel fees, expert witnesses, and the risk that the arbitrator sees the record and awards more than they were offering. That change dynamic shifts leverage towards the injured worker. The number available in that context is often meaningfully different from what was available at the voluntary offer stage. Many workers in Illinois who waited and then accepted whatever came first didn't know that the path to a better outcome was pressing the case forward. They were waiting for the insurance company to come to them. The system does not reward passive waiting. What I look for before advising accept or reject. When a client comes to me with a settlement offer on the table, the analysis is not whether the number sounds good. It's whether the number reflects what the case is worth under Illinois law and whether the full picture of the injury has been documented. I look at the TTD component. Were benefits paid correctly through the full period of disability, or was there a gap? I look at the medical record. Does it fully document the scope of the injury, including any permanent limitations? I look at the wage rate used to calculate the settlement. Was that average weekly wage calculated correctly? Overtime and bonus payments are often disputed in AWW calculations. They are excluded by default under Illinois law, but mandatory or consistently scheduled overtime may qualify under case law. This is an area worth reviewing carefully. I look at the PPD rating. Does the rating the insurance company is using reflect the actual functional impact of the injury on this worker's ability to do their job? I look at comorbidities and future medical. If the injury will require ongoing treatment or is likely to worsen, that value belongs in the settlement and needs to be accounted for explicitly. A number that closes out the case without accounting for future medical can look fair today and be inadequate a year from now when treatment needs arise that the settlement should have covered. And I look at whether any recovery was missed entirely. Workers' comp is not always the only avenue of recovery in a work injury case. If there was a defective piece of equipment, a negligent third party, or other circumstances that go beyond the pure employee relationship, those may support additional claims that a workers' comp settlement alone would not resolve. When waiting is strategic and when it isn't. If you're at MMI and the insurance company has not yet made an offer, waiting a reasonable period while your attorney builds the record and prepares the case for IWCC filing is often the right move. Offers tend to approve as the hearing date approaches. If you're pre-MMI and treatment's ongoing, the general principle is that you don't want to settle before you know the full extent of the injury. Accepting a settlement while your medical picture is still unresolved is almost always a mistake. But there's a version of waiting that doesn't help anyone. If you've been waiting for months without an attorney, without a petition filed before the IWCC, without any pressure mechanism on the insurance company, you're not in a strategic waiting position. You're just waiting. That waiting does not move the number. It just creates the risk of missing something, a filing deadline, a notification requirement, a procedural step that needed to happen and didn't. You've been waiting more than 6 months. If your workers' comp claim has been open for more than 6 months and you don't have an attorney and no offer's been made, that is the moment I'd ask you to reconsider the calculus of handling this yourself. The statute of limitations for workers' compensation claims in Illinois is 3 years from the date of the accident or 2 years from the date last payment of compensation, whichever is later. That clock is running. And the value of having someone filing a petition, building the medical record, and creating pressure on the insurance company timeline often exceeds the fee charged for doing it. The standard arrangement for workers' comp attorneys in Illinois is a contingent fee, which means you pay nothing unless your case resolves. If the case settles for more with representation than without, the fee is covered by the increased recovery. The consultation to find out whether that's likely is free. There's no reason to wait another 6 months before having that conversation. If you want to understand how MMI specifically affects settlement timing, and what the insurance company does with that declaration to control when and how much they offer, there's a full video on that on this channel. MMI is the most important pivot point in the entire Illinois workers' comp settlement process, and most claimants never see it coming. Watch that next. And if you're sitting in an open claim right now, wondering whether you should still be waiting, contact information is in the description. That call is free.